Good morning, everyone. My name is Erin Kopek, and I'm the marketing coordinator for Extra Help. It's about 9:30 here, so we're going to go ahead and get started. Thank you for tuning in today to our Workplace Excellence webinar entitled Essentials of Employment-Based Immigration. Today, our presenters are Celine Awad and Hasha McQueen, and they will be introduced momentarily. The Workplace Excellence webinar is an exciting new program that we started about a year ago for our clients and colleagues to help manage their workforce changes and workforce efficiency. The call will last about an hour. All of the attendees are set up as listen-only mode. If you were to have any questions, feel free to pose those at the very bottom of your screen. You'll see a question section where you'll be able to type in that messaging function. So let's get started. Let me introduce our speakers. Celine Awad is a co-owner and attorney of the St. Louis-based law firm McQueen Awad LLC. He represents the firm's clients in litigation, transactional, and administrative matters. He routinely handles cases in the area of business, immigration, and international law. Celine is a graduate of St. Louis University School of Law and holds a bachelor's degree in intelligence analysis. Hasha is a co-owner and attorney of the St. Louis-based law firm McQueen Awad as well. She's a second-generation immigrant, fluent in Spanish. Her practice areas focus on general corporate law, immigration law, and international law. Prior to graduating cum laude with a law degree from Southern Illinois University School of Law, she served as a captain of the U.S. Army. Hasha earned a master's degree in human resource management from Troy State University and an undergraduate degree in communications from the University of Tampa. Thank you for joining us, and I want to turn it over to Celine and Hasha today to introduce our webinar.
Thank you so much, and thanks everybody for coming. This is Hasha, and we are going to get started. Let's talk about the visas and what they are. Okay, so you'll hear a lot of people, they'll say that I have a visa for this or a visa for that. Well, a visa is simply something that is received by the embassy or consulate in another country, and it's affixed to a person's passport usually, and it looks something like the picture that you see there at the bottom. And what a lot of people don't understand is that sometimes you may have a visa, but they won't allow you inside the country. And that is clearly just because the immigration officer at the port of entry has all the authority to allow you in or not to allow you to come in. Okay, so this next slide we're going to look at is the I-94 card. And that is the actual permission that you have to be in the country. So when you come in and they say, okay, you can come on in, then they'll give you an I-94 card. It looks like that sample that's on the screen. And that gives you the dates to how long you can stay in the country. So immigration is made up of 3 separate agencies. And these agencies, they operate separately but together at the same time. And you can see how that can cause a lot of trouble. Well, the departments that are involved are the U.S. Department of Homeland Security, also known as USCIS, which is the agency under that. And a lot of you may know that as the INS. That used to be the INS. Then you have the U.S. Department of State, and those are the embassies and consulates that actually issue the visa. And then you have the U.S. Department of Labor. And the Department of Labor does 2 things. They make sure that the person is getting paid enough, and they also make sure that there's no other U.S. citizens to do the job. So there are your line of non-immigrant visas.
And before we get into these, we just want to clarify that the concepts that Hasha just spoke about are just fundamental concepts that any employer needs to understand when they're hiring foreign workers. Obviously, this is a concern primarily for the workers because they're the ones actually in the country as a visitor for employment purposes. But it's important for the employer to be able to get all these concepts very clear within the organization so that compliance is accurate, and when the I-9 process starts to get on its way, because you have foreign workers, you don't have any issues with agencies involved with regards to the compliance of employing these workers. So there are two big groups of employers. There is one that is a non-immigrant visa, and the other one that is an immigrant. So a non-immigrant is somebody who comes to the United States with an intent to come to the United States to work on a temporary basis. And the employer needs to know that, because what that means is that the worker is only going to be in the U.S. working for that company for the set amount of time that is set by the USCIS time standard set up for that particular visa. Now, on the immigrant visa, it's going to be a situation where the worker comes to the United States as a resident of the country, and they're allowed to bring their families and stay here for a longer period of time, even later on become a citizen in the United States. So we're going to start with the non-immigrant visa options that you as a business owner have and that can utilize in order to bring foreign workers into the United States.
Yeah, very good. Yeah, and that is an important concept to know between non-immigrant and immigrant, because a lot of people think that when you say non-immigrant, you mean a citizen, but that's not true. Okay, so legally speaking, non-immigrants are the visas that you see in front of you there, H-1B, TN, LO, and it's alphabet soup because it's basically referring to the statute, the Immigration Naturalization Act, and that's the paragraphs. So H-1B is the most coveted one, and you can see you'll need at least a the actual position needs to at least require a bachelor's degree. And for all you fashion models out there, I don't know how many you have, you may, that also falls under that. Then you can apply for permanent positions while you're on the H, and that's the intent issue. And Celine, you want to explain that?
So the intent is a very important issue with the immigration agencies. The important thing is under one, the mindset that the worker and the employer have when they process this paperwork. So if you have an intent to come on a temporary basis, obviously you got to apply for something like an H-1B. Now, if you're going to come on a more permanent basis, an H-1B is not going to be an option. But an H-1B is a very good tool for companies that have specialized workers. Let's say a program developer or an engineer are that type of work and profession that will require something like an H-1B, which later on can be extended up to 6 years. And importantly, then later on, the worker has an option to change the intent to something more permanent. But that doesn't come until the H-1B visa is finished after the 6 years.
Right, because the H-1B is one of the only visas, one of the only visas that you can have we can have what's called dual intent. So you can have a permanent and a temporary intent and still be on the H-1B. No, some misconceptions that you can apply for an H-1B at any time. That is not necessarily true. There is a cap on those, and if the cap's reached, then you really can't apply. The application is the only hurdle that you need to clear. That's not true as well. Employers need to make sure that they have certain requirements that USCIS has put down, so to put in the client's folder, for example. So if you receive an employee that is an H-1B, you need to have compliance with those rules. Go ahead. So another misconception is you must first prove that you cannot find a qualified worker for H-1B. That's not necessarily true. That is for immigrant visas, not for non-immigrant ones, and in particular not the H-1B. Also, there's a misconception that this is cheap labor. This is not cheap labor. There's something called the prevailing wage, and again, the U.S. Department of Labor is the one that deals with that, and so they're the ones that put down how much you should be paying your workers.
And I think every company in the United States that is going to consider even start the H-1B process because they need professionals to help them out in their companies is going to first try to hire somebody in the region or within the United States. So if they're going to start this process, it's generally because they can't find anybody here. That's really going to be the case. It's not a cheap process. It's a complicated process. but it's doable and it should be done, and it's something that we want to promote as a tool for an American company employing professionals, because as we all know, the workforce has been globalized to an extent that we can not only utilize the resources here in the United States, but if we cannot find it, then go abroad and get those professionals that we need. And the government recognizes that, and that's why this program is in place.
Okay, so we have the TN visa, and that deals with NAFTA. So Mexican Canadians can get this visa. This is a very important issue to remember about this type of visa, is that it's professional. So almost every single professional category that is for the TN requires a bachelor's degree. Okay? The only one that does not require a bachelor's degree is a management consultant, and that category is highly scrutinized in immigration. Also, you can do this at the border. Okay. Okay, so the L1, there's a difference between L1A and an L1B. L1A is for managers in multinational companies, so international managers. L1B is employees with specialized knowledge. So there's a difference there. There's a requirement for being abroad for a year. They have to be working with the company there for at least a year, and once they come over, the company has to keep operating. So you can't just set up a company and then have the person come over and then that company goes defunct. You can't do that. So the L1 is actually used for a lot of larger companies or companies that have overseas presence. Okay, so the B1, business visitors, you will hear the visitor's visa being used for a lot of different purposes. For our purposes, there's a difference between the B1 and the B2. The B2 is a tourist visa. That's when you come over and you decide you want to go look at the arch or something. Okay, so that's the B2. The B1 is when you're coming over here for business, and you can see some of the consulting that you can do, traveling for training, negotiating a contract, etc. But you cannot work. You can't do anything that looks close to work. Okay, you can get reimbursed, but you cannot work. O1 visa. Okay, these are for really extraordinary people. These are going to be few and far between on these, but it's something you should be aware of. So if you have somebody who is the top of their game in their industry and you need to bring them over, this is what you would use. H-2B. H-2B is a common one as well. There's also a cap on these. These deal with temporary services, seasonal services. This is very, very popular in the lawn and landscape industry. Okay, so you bring people over for a short period of time. You'll also hear what's called the H-2A, which we're not going over, but that's the agricultural one. It's the agricultural equivalent to this one.
And if it feels that we're going through this a little quick, fast, it's because we are. Because we could spend an hour in every one of these. But we just wanted to give you an overview of what each one of these are and the different possibilities that you have to hire foreign workers. So far you can see the level of skill of the worker is important, the amount of time that you need to keep the worker here is important, and maybe the position with the company, if you are a large company, is important.
Okay, and then we talked about the H-1B1, again, is going to be very narrow. This is for Chile and Singapore aliens or foreign workers, and so that's an option. So you have somebody from Chile or Singapore, you may consider this option. E-visas, we like the E-visas. These are out of treaties that we have with other countries, and we have the treaty trader one, and then we have the investor one. And then we have a special one for Australia, and that's the E3. Okay, so if you're a student or if you're here for training in M1, then you can work under particular circumstances. You can do what's called curriculum practical training, OPT, which is optional one afterwards, and then of course they have a special one for STEM now, which is science, technology, engineering, and mathematics. So if you have a student that wants to work, normally after they graduate, they will get 1 year or more, if they're in STEM, to work for an employer in accordance with whatever degree that they obtained. Now, I want to say after they get after that year, they're going to have to apply, or before it expires, you want to apply for one of the other visas so that they can maintain their status.
And here you can see in this slide other types of non-immigrant visas for temporary workers that, like I said, we can talk about each one of these for an hour, but these are other options that are available. So you can look at that and kind of get an idea if the worker that you want to hire doesn't fit any of the other visas. We also have these available, and if one of our clients, for instance, comes to us, okay, we need this type of worker from this country, we're going to look at all the options and determine which one is the best fit, and then move forward with that particular visa. But you see the H-1C, the H-2A, H-3, foreign media athletes, all type of different visas that are available. Depending on what type of worker you're in.
Yeah, you can see how the really well-known athletes are coming in, like the P1, you know, and the entertainment groups, so the singers or whatnot. Okay, keep going. All right, now we're going to talk about immigrant visas, and Salim already talked a little bit about that, about how these are really particular for the intent to come in and work permanently.
So 5 categories. We'll start with the first one.
Okay, so EB1 is somebody who's got extraordinary ability. Okay, so this is kind of like the O visa we saw before. This is people that are very outstanding in their field. Now this is also like the L1A, which is the multinational manager that we talked about before, where the company has to have an overseas presence. Okay, so this one is very highly sought, because you don't have to have a labor certification. And what that means is you don't have to go necessarily and see whether or not there's any U.S. workers to do this job. Or you also don't have to ascribe to the pay and all that. So because normally, most of the time, these people are getting paid way high salaries.
And let me reiterate the fact that when you're in these categories, when you're an immigrant, your intent is going to be to maintain residence in the United States permanently. So, which is very different than temporary, where your intent will be to come, do the work, and go back home.
Right, and again, with, just as some terms that you should consider, immigrant, green card, all mean the same thing. Permanent residency, that's all the same. Okay, so so you don't get confused. You'll hear those phrases a lot of times, and that's all the same thing. So here we have an EB2, and these are people that hold advanced degrees, okay? And also, there is a labor certification requirement here, but if you get a national interest waiver, then you don't have to do the labor certification. And what I mean is, if you're like a researcher and you're curing cancer, I mean, that's not something you're going to advertise for, right? So the labor certification is required in that case, but you have to qualify. And then EB3 is almost like everything else. EB4 we're not going to go over, but it's just a lot of smattering of different immigrants that want to come in for different reasons. EB5, you may have heard that in the news recently, especially around here. The World Trade Center has an organization, it's called Gateway, I believe, that has just been approved as a regional center for EB5s, and that just opened up last March, I believe. So you'll be hearing this a lot in the area, and this is basically just saying, if someone's got an investment, if they're an investor from a foreign country and they can put down $500,000 or $1 million and create 10 new jobs, then we'll take them.
Right, so this is a very popular one because a lot of U.S. companies are looking for sources of investment. And when investment is not available in the United States, this is a good way to allow foreign investors to come into the U.S., obtain a permanent residence in the United States with them, their family as well, and be able to support the investment required by the U.S. Business. So becoming very popular in regions like St. Louis, particularly, where you have a lot of startups. In Texas, it's also very, very popular. California, because it provides a good flow of capital for these new companies. So we will really like to. I'm sorry.
So we breezed through that.
We did breeze through that, but I think it's important from the people that we have on the audience. We would like to see what questions they may have, and encourage you. And we put our emails in there because I know there are going to be thousands of questions, and we want you to feel free to contact us with any questions. And if there is anything we can do to help you, we'll be more than glad to do that.
Let's see, I don't see that there's any questions. We had one of our attendees, they asked, what industry did you say? But I'm not exactly sure what piece of the presentation they're asking about.
What industry?
Let me see.
Well, we find that employment-based visas are utilized a lot in the IT field, the medical field, and really all the STEM professions, engineering and such, because we have quite the shortage in the United States. So we are utilizing a lot of these tools to bring professionals in the United States. Now, there are others that are utilized for seasonal workers, like the H-2Bs, when we have situations from like landscapers and companies like that require people to come to work in the United States only on a temporary basis, although they're unskilled, and that provides a good source of labor for these companies.
Yeah, I would say also it could be any industry. Cecilia's right. There are certain industries that tend to utilize particular visas more than others, but really you shouldn't feel restrained. I mean, if it's a position that requires a bachelor's degree, then we can make an argument that it is an H-1B position and can apply for that. So I would say it just depends on the situation.
Sure. They wanted to know, when they asked about the industry, they typed in further about what about the agricultural side?
Yeah, this is an H-2A, and those are, workers that have to come in seasonally, just as an H-2B would. And they would have to go through that process to get workers, and it's a similar process. So you'd still have to do the advertising and et cetera on that.
And importantly, on that one, you can group the workers, so you can have a number of workers that you can do one visa process, and we've done this many times before for several workers, whatever your requirements are.
Right. So some of these, like the H-1B, usually there's no group workers on those. For the temporary ones, for the H-2A and H-2Bs, you can group them all together, and you don't even necessarily have to have names either on some of these, depending on what country they're from, too.
Okay, another question. Are you willing to make your PowerPoint slides available to the attendees?
Absolutely.
Sure.
Okay. And another one. What is the process once the H-1B employee is applying for perm?
Okay, so you've got a worker and they're an H-1B and you want to keep them permanently. It's a complicated process, but I'll try to simplify it. So you remember those departments that we had up there? Well, Department of Labor would be the first one you would do, and you would go through the labor certification process, and that entails advertising for a set number of months, and documenting everything, and then not finding a worker that can do the job that has the qualifications that you put down. So but let's remember that means they have to have the minimum qualifications. If there's a U.S. worker that comes in and has the minimum qualifications, then you have to have an employment reason why you're not hiring that person. Okay, so then once they go through that, you go through that process and you find no one, then you apply for the, you do a petition for alien worker. Okay, and so that's the permanent residency application to USCIS, which means the Department of Homeland Security, so it's another department. And you submit all the paperwork there, okay, and then you wait. Now there's other factors, and you know, like I said, it's a complicated, long process. Timing-wise, I would say it takes a couple of years, but it depends. It depends on if your worker is from a particular country like India, China, Mexico. These are called breakout countries, and that means they've reached their cap for the number of workers that can receive green cards. So if they are, they have to wait, and sometimes the wait process can be about 10 years. I mean, I don't try to scare anybody. That's just it just depends. It depends on the timing of the application.
Timing is very important in everything related to employment and immigration. I'll give you an example with the H-1B, which is a very common visa that we work on. You have to be sure to submit that application by April 1st. And the reason for that is because the cap for H-1B is 65,000, up to 20,000 more to 85,000, but it's still small because this is supposed to give enough numbers for all the companies in the United States that are requiring foreign professionals to come in the United States. So as you can see, that number is going to be very low. So the window opens on April 1st. The packet has to be submitted on that day. Sometimes the cap is met that same day or maybe 1 or 2 days later. So important to start on time, 1 or 2 months before, to put all the requirements through the labor certification and to be able to submit that packet on April 1st. After you submit the packet, you want to make sure that the packet is absolutely perfect. And that's one of the things where we come in many times to fix those problems. And, you know, a lot of people say, well, I can just get it done internally. And you know what? You're free to do that, obviously. But a lot of what we encounter in our practice is applications that have been denied and they receive what is called a request for evidence. And then we have to fix the problems. And this generates a number of delays and really a lot of extra costs for the employer. So we want to get it right from the beginning and ensure that we have everything absolutely perfect so that it will dramatically increase the chance of getting that work in your company. Obviously, nothing is guaranteed given the low cap and given the very difficult standard to get through this, but I think the chances are much higher when you get it right the first time.
Okay, there's another question. Do the EB categories allow spouses to seek employment in the U.S. similar to the L2?
Okay, so you're talking about two different things. You're talking about the immigrant visas and then you're talking about the non-immigrant visas. The EB categories are permanent residency categories. So once the worker goes through all the gyrations that the U.S. Department of Homeland Security and U.S. Department of Labor want them to go through, then what would happen is normally the spouse is added to that application, and then once it's submitted, then they'll get back what's called an employment card or it's an employment/travel card now. It's all done in one fell swoop. And that usually comes back 3 months after the application is submitted. Now that's the application to the USCIS, not to the U.S. Department of Labor, which would be the labor certification. So once you pass through the labor certification process, then at that point, once you submit that packet to USCIS, that's when you get the spouses and the worker can get back what's called the travel employment card. And that's about 3 months after the application is submitted. Does that answer your question?
All right, feel free to type in. We'll give you another couple minutes for questions. If anyone has any further questions, feel free to type those into the messaging box. The slides today will be available. We will send those out to everyone that has registered and viewed our presentation, and they will also be available on the Extra Help website at extrahelpinc.com and on the Extra Help Inc. YouTube channel. So feel free to view the presentation again on there, and feel free to reach out to our presenters today for any more questions. Otherwise, we will, anything else you would like to add?
Well,
Go ahead.
I got one thing. You know, don't be, really the big picture of this is don't be afraid of reaching out to the foreign workforce. Sometimes for a business, it's very important to be able to have those people that are just going to be the right fit for the company because of the skills or because whatever other reason. And if you cannot find it in the United States, there is a number of countries from which we can tap that type of workforce. So don't let your business slow down because you can't find the right people. There are resources in America. If you cannot find them here, you can look abroad. And that's what this process is in place. And it's not hurting anybody in the U.S. It really is helping your business reach the goals that it's set out to reach. And so we're here to help you through that process. Don't let yourself be intimidated. And hopefully we can be of assistance to you in the near future with your immigration needs or any other need you may have.
Right, and I just want to add one thing. Don't wait till the last minute to come to an attorney or anybody to start the process for any. We always tell people start early if you've got questions. Or you think that you have a worker that you might want to keep, you probably need to contact somebody.
I know we're located in St. Louis, but immigration is a federal practice. So as immigration attorneys, we're capable of practicing anywhere in the United States. I wanted to make that clear, and we're also licensed in Illinois, so we'll be more than glad to help you whatever you need.
Okay, I think that ends our presentation. Thank you for taking the time today. Appreciation to both of you. That concludes our webinar for today. Everyone stay tuned for next month. We will have one coming up on February 20th, and that will be at 9:30 a.m. as well. Thank you both for taking the time today.
Thank you, Erin.
Thanks.